litigation. But what is it? Okay, there are two ways to get a judgment in a lawsuit, which is through a trial or through a summary judgment. Now, you can finalize the case through a settlement, or maybe the case gets dismissed. But if we're talking about going all the way through and getting a judgment, there are really only two ways to do that. Now, trial is its own thing. It's very expensive. It's quite the ordeal. And if you can avoid it, it's great to do so. And how do you avoid it? Well, you go for a summary judgment. First, let me lay out the traditional understanding of when you can even go for a summary judgment, because it's not available in every case. Ultimately, it comes down to whether or not there are any factual issues that have to be decided by the trier of fact. That would be the judge or the jury. So, if the parties disagree on what the actual facts are, the facts that are material to making the decision, then summary judgment is not going to be available. So what would be the kind of cases where we could actually get a summary judgment? Well, contract cases, those are a classic, because, if they both agree that there's a valid contract and the only question is the interpretation of the contract, well, that's perfect for a summary judgment, because the judge will read the contract, hear the arguments, and then just make a decision. It's a decision of law. It's not a decision that involves findings of fact. Okay, now I'm going to start carving away from them, because that's kind of the easy part. Let's now get into the subtleties here. There might be some other ways that we could use summary judgment. Like, let's say, for example, there are factual issues. There are things that the parties don't agree on factually, which is usually the case, However, let's say that we're the defendants. We're going to come forward with a summary judgment saying, Judge, it doesn't matter. You can construe the facts as they say it. Take all the facts just the way they say it. We don't agree, but let's, even just for the sake of argument, just take all the facts and assume that they're true. Their story is true. Nonetheless, we have a defense here that, as a matter of law, trumps all that. So that could be a situation where you could still use a summary judgment. Okay, now I want to segue just a little bit into, traditionally, it's been difficult in Florida to get a summary judgment, and I'll tell you why. I think it comes down to judges don't like being first. And the appellate courts are very fond of sending stuff back to the trial court because a summary judgment was granted when the appellate court thought that there was an issue of material fact that made summary judgment inappropriate. And so they don't really have to get into anything other than, Judge, you shouldn't have granted this on a summary judgment, should just do the whole thing over again. Well, that's no good if you're a judge. You don't like being reversed. You don't like being told by the appellate court that, you made the wrong decision in granting the summary judgment. So it has traditionally been very difficult to get a summary judgment. It had to be a very clear-cut case. And even then, sometimes the judge would say, let's just go to trial. Let me pause there. As an aside, If the judge says, let's just go to trial, I'm not giving you the summary judgment, that's not the same thing as losing. You know, he lost on that motion. You're not going to get the case done at summary judgment, but the judge is not saying, I don't like your case, you lose the case. He's just saying, he or she is just saying that this case is not appropriate for summary judgment. I'm going to want to resolve this at trial, not here in this, in this shortcut form. But back to the matter at hand. Okay, now, the law has changed within the last couple of years. I'm old, so it still feels new to me, but it's not new anymore. The law has changed in Florida, whereby we have adopted the federal rule regarding summary judgment, and that has some notable differences. The new rule is designed to make getting summary judgment easier. And if you think about it, that would be great, right? If we can shorten up these cases, make it cheaper for people, speed up the whole process, the more summary judgments, the better, right? So now the way the summary judgment rule reads is that, okay, whoever's asking for the summary judgment, that's the moving party, they just have to carry their initial burden. And once they've carried their initial burden, then we're going to shift the burden over to the other side to prove to their some reason why summary judgment should not be granted in this situation. Maybe that doesn't sound like a big difference to you, but in theory, it should be a very big difference. It's already amazing that, as the moving party, you don't have the burden. That's unheard of in our system. Really, if you're the one asking the judge to do something, like you're the one moving for the summary judgment, then you expect to have to carry the burden all the way through, and that's always been the case. But now, the new rule has this burden shifting feature to it that theoretically should make a big difference. Now, in my experience, has it made a huge difference? Maybe not. For a couple of reasons. You've probably heard this in law. It's so conservative. Everything's happened so slowly in the world of law. And, like me, these judges are old, and so it feels new to them. I think they're still getting used to this whole idea that they can decide cases on summary judgment and not get reversed. Now, why do I give you that little bit of insight? Well, it's because if you're my client and I'm telling you, look, based upon the rule, the way it's written, I think that it's worth it. We should pay the money, take the time to draft the motion for summary judgment, go to the hearing. I think that under the rule, the way it's written now, we stand a good chance of prevailing. But I can't guarantee you that. I might be right. Maybe this case should be decided on summary judgment, but I can't guarantee you that my judge is going to be, progressive enough to stick his or her neck out and rule on summary judgment when it's so much easier and safer still for the judge to say, let's just go to trial. So I have to give you that little caveat. Look, if it's pretty clear that there are factual issues that do bear on the outcome of the case, I'm not going to suggest that you waste your time on a summary judgment, your time and your money. I'm going to tell you, almost impossible that you're going to get this done at summary judgment. Let's just put our time and our resources into preparing for trial. But you can understand the temptation, right? If we can get it done at summary judgment, how much better is that? It's much better. Now, I don't know if you guys have thought about this before or knew this, but the way it works under the Florida Bar's rules is that clients determine the outcome of the case. Like if you're going to settle, that's the client's decision. You guys make those ultimate decisions as to, whether to continue a case or settle. But when it comes to the tactics of a lawsuit, that is actually up to the attorney. It's up to us to determine the best way to accomplish your goals in the lawsuit. So I could just say, listen, guys, it's my call. Take my word for it. But I don't like doing that. I very much prefer that you understand the subtleties to it, that you can see how, we're making the best decision we can, but we don't know for sure how it's going to play out. So that we can have an intelligent discussion together. You can kind of give me your blessing. I much prefer that. Okay, in conclusion, let me just recap. So, first of all, if there are factual issues that are in dispute, like the parties don't agree as to what went down leading up to the dispute, then in most cases, I would just say, okay, forget about summary judgment. Let's not waste our time and money trying to get that because, it's not appropriate. The judge is definitely not going to give it to you. Unless, one little carve out, unless you have an argument that you can go to the judge and say, take their story as true, exactly what they say, it's not true, but let's assume that it is, because I have an argument that despite all that, still trumps, and you can give me a summary judgment as a matter of law. If you have that golden bullet, then you might still be able to go for a summary judgment. Now, is there a good chance the judge is just going to be, scared and just send you to trial anyway? Yeah, that's a fair possibility. Okay, final point here. So now let's say you do have a case that is really rather appropriate for summary judgment, like there are few facts or no facts that are in dispute. go for it, because even if there are, like, some facts that are maybe not material, but they are somewhat in dispute. Now, if you're able to carry your burden as the moving party, give good reasons as to why you should win this case, then that is going to shift the burden to the other side. And it makes a big difference, because it used to be that the other side didn't have to have like any evidence or anything. They could just say, no, we disagree about the facts, so we have to go to trial. That's not so anymore. Now, because of the new rule, not really new, but feels new to me, under the new rule, that's not good enough. If you bring enough initial evidence supporting your case, then they have to come forward with evidence of their own, enough to rebut, so that the judge is forced to send you to trial. So that's summary judgment in a nutshell. That's what I got for you guys on this one. I'm sorry I missed you last week. This is my excuse. Hey, tomorrow's my birthday, so throw a brother a bone. Give me some likes, some comments. Give me something there, and hopefully I'll be in better sorts next week. So see you then.